49, People versus Avery Baker. Counsel, give us a second. While it seems like the courtroom is emptying out a little, it's not you. They just want to leave, you know? So give them a minute. Okay, counsel, I think we're okay now. You wanted some rebuttal time?
Yes, 6 minutes, if I may.
6 minutes, okay.
I thought they were all here for my case. But
Only the diehards are left.
I'm sorry?
Only the diehard Court of Appeals, groupies are left for your case.
Right.
And we're left. We're diehards. We want to hear it. Go ahead.
I don't have any particular strong feelings about in what order I address these issues. If the court has any
No,
preference.
you go ahead.
Okay.
We'll believe me, we'll stop you.
I'm sure you will. So I'll start with the public trial claim because I think this clearly was a constitutional violation. And I don't think any great mental gymnastics are required to find it.
Is the Constitution violated every time a judge makes a mistake and excludes somebody he shouldn't exclude?
No, but don't forget, we're talking about a public trial claim here.
Yeah, but a right to public trial is not absolute
No, it's not
by
absolute.
any standard.
It's not absolute, and a court may sequester witnesses. I'm not arguing that a court can't do that. But what a
But
court...
if it makes a mistake about who is a witness and who isn't, it thinks someone is a witness and mistakenly excludes her, that violates the Constitution?
I believe so. Absolutely. And I think the court should be mindful of Presley versus Georgia, which was decided just a couple weeks ago by the United States Supreme Court, which reaffirms a lot of the principles that I've argued to this court.
It doesn't look like this trial judge took an extreme position. He allowed the defendant's mother to remain in the courtroom, and this
but
woman was on a witness list, correct?
she was on the witness list, and then defense counsel said she's not going to be my witness.
But the people then said that they may call her as a witness.
As
Based
a
on what?
rebuttal witness, right?
Based on what? They said that after the judge said, well, I'm going to exclude her unless the people say she might be a witness for them. So what are they going to say?
Well,
She might be a witness.
It could have been tactical. I must say, I don't quite understand the tactic, but it could have been tactical. They could have thought they would get some advantage by not having this woman in the courtroom. But it also could have been a good faith representation. Maybe they were going to call her. Why is the judge not entitled to say, well, I think it may be good faith, so I'm going to send her out?
Well, good faith based on what? They made no proffer of potential relevance even when invited to by the court. So if they're just going to say vaguely, well, she might be a rebuttal witness, and of course at that point we don't even know if the defense is going to put on a case, I don't think that's good enough to justify an exclusion. I think they have an obligation to say this is why we think she might be.
I guess what I'm saying, I'm suggesting, yeah, I see your point. I mean, the argument may have been a very, very poor one, but why don't we have to give the judge a lot of leeway in this sort of situation? It's a decision that has to be made on the spur of the moment. He doesn't know all that much about it. He doesn't know whether people are engaging in gamesmanship or really worrying. Every now and then he calls one wrong. Doesn't he have a lot of discretion?
Well, there's some amount of discretion, but it's circumscribed by the rules under the Sixth Amendment. I don't think you can say, well, you know, the judge may have made an honest mistake, therefore it's not reversible error. That's not the test.
No, but I thought that it's somewhat unclear in the record as to whether the defense attorney was or wasn't going to use her, because I thought he indicated he couldn't talk to her because her lawyer wouldn't allow him to speak with her.
That's correct.
Which kind of led, I could see where the judge might be led to believe there was a potential that perhaps the defendant would call her.
The judge didn't say that, and the people didn't argue that. That came up for the first time in the appellate division when they said it, and not in response to any argument on that point. And if that was the judge's justification was, it wasn't even what the people argued. that she might be a witness. He said, well, her name was mentioned to the jury, potential jurors, when the witness lists were read, and on that basis, I'm excluding her. You know, after defense counsel says, decides, I'm not calling her as a witness. Now, I mean, what does that have to do with anything? That her name was read to the jury? Is that what we decide a public trial claim based on? I think the judge was straining for a justification to keep her out of the courtroom. And I think the people were doing everything they could to keep her out of the courtroom because they didn't want anyone there to provide moral support to the defendant. I think you need
Well,
to...
if that was the judge's intent, why did he allow the defendant's mother to sit through the trial?
Because I think, well, I couldn't say what was going through the judge's mind. Maybe he realized that if he gave the people everything they asked for, he was going to get reversed. I think we need to look at some policy implications here. If we're going to allow
That's an awfully
this...
skeptical view of the jurist here, isn't it?
Of the who?
Of the judge here.
Well, you know, I'm not one of those people who makes a pretense that every criminal trial judge in New York State is even-handed. I'm not going to say that, even if you want me to, because I've practiced in trial courts and I know the reality. And I've seen plenty of cases where it was pretty clear that trial judges were trying to help the prosecution get a conviction. I'm not saying necessarily the judge is doing that here.
You don't
I'm
have
sorry?
that. You don't have an allegation of that being the case
No,
here.
and I'm not suggesting it, but I'm not going to stand here and join in some fiction.
What you're suggesting is that we should have, whatever the rule is, the rule should be one that recognizes that judges are sometimes flawed human beings.
Absolutely. If we didn't have recognized that, then there would never be any basis to reverse. I think what we need to keep our eye on here is this. A prosecutor says, well, this person might be a witness, automatically the person gets excluded from the courtroom. Now, if that's going to pass constitutional muster, then you're going to open a door in every case, whenever a prosecutor thinks there's someone in the courtroom who's there to provide moral support to the defense, Judge, I can't put my finger on it right now, but we might call this person as a witness, therefore this person should be excluded. I mean, I don't think the court should be in the business of emboldening prosecutors to do that. Unless there are more questions on that point.
Go on to the summation issue.
Thank you.
Go ahead.
I did want to reach the ineffective assistance claim. I want to make
Okay,
sure I reach
do
that.
that.
Because I think that's a very interesting issue.
Go ahead.
And obviously, it depends on whether this case falls within Gallagher or Trappier. My position on that is very clear, and I think the law on that is very clear, that this is not, as the trial judge concluded and as defense counsel agreed, a case that comes within Trappier, because this is a homicide case, not an assault case in which a defendant's conduct can also create a risk of death.
Do we even have to get there, Mr. Kessler? Do we have to decide that question? I mean, couldn't it be possible that the defense attorney had a strategic reason for wanting to have all of these charged in the way they were charged?
One could possibly conjure one up, but the problem is it doesn't appear in the record. What defense counsel...
Well, defense counsel usually don't disclose their strategic reasons on the record, do they?
No, but the court can't speculate on it.
Isn't the rule in ineffective assistance cases that we have to exclude a strategic reason, or otherwise you have to make a 440 motion and have the judge decide as an issue of fact whether there was a strategic reason for this?
I think the court has to consider whether there were strategic or tactical reasons. Now, a strategic or tactical reason could also be a bad strategic or tactical reason and result in ineffective assistance.
You said you might conjure up a reason. Have you conjured one?
I can't, because frankly, I think if the court rules that this was not an effective assistance, I think it's undermining its own precedent represented by People v. Gallagher.
Well, even though you think, I mean, is it so clear that this is not Trappier that the trial counsel couldn't have thought it was?
Absolutely. People v. Gallagher makes it clear. Trappier was an assault case in which the defendant's conduct was also found to have created a risk of death. It happened to result in injury instead of death. The rule is different in a homicide case. Gallagher, in a line of cases represented by Gallagher, makes that clear, that this is clearly Gallagher, not Trappier. And the reason I think it's ineffective assistance is because in Gallagher, this court observed that it's inherently prejudicial to a defendant for a jury to not be required, when you have a top count and lesser included counts based on different mental states, not to be instructed to consider the counts in order instead of returning
Was there a
verdicts
lesser
in order.
included? You're not saying that the top two here, that there was a lesser included as between, what were they, manslaughter,
There were
murder
two
and
manslaughter counts and there was a depraved indifference murder count,
Okay, now,
all prescribing the same result.
well, okay, where's the lesser included?
Well, maybe I misspoke on lesser included. I think one of them was a lesser included and one of them perhaps
The
was.
manslaughter, too, is a lesser included to the depraved indifference, right?
Yeah, reckless manslaughter is. Generic reckless manslaughter. There was another count based on the age of the child. But the fact is, these were three distinct mental states directed at the same result. Now, what the court said in Gallagher was, where there is but one homicidal act and one death, it follows that allowing two convictions could be no favor or advantage to the accused. It confers an unintended advantage on the prosecution, enabling the people to secure a double conviction instead of simply protecting against an empty prosecution, and it allows the jury to avoid determining the key issue of mens rea, which is exactly what happened here. And I would add to that, when a jury is specifically instructed, as they were here, to return a verdict on all three counts, all three homicide counts involving different mental states, instead of being told to make a determination of which of these mental states the defendant acted with, there's much less of a chance that the jury is, number one, going to
There were
reach
only
a
two
compromise
mental
verdict.
states, actually,
I'm
because
sorry?
one was a lesser included of the other, so that was, so that one had to be in the alternative to the manslaughter one, correct?
And also, the other count, even though it technically might not have been a lesser included, had to be charged in the alternative. This is like a murder case where you have intentional and depraved indifference murder charge. The rule is the trial court has to instruct the jury to consider them in the alternative, even though the one's not a lesser included offense of the other.
You say there were two inconsistent counts and one lesser included to one of those two inconsistent counts.
Yeah. Essentially. I mean, I think all three were inconsistent because
They can't be both lesser included and inconsistent.
well,
You're not lesser, if you're lesser included,
maybe
you
I'm
have to find
misspeaking.
one to find the
I'll
other.
take your statement.
Two of them were intentional.
I'm sorry?
Sorry, two of them were reckless counts, and one of them was an intentional.
One involved an intent element.
All right. So that group should have been charged in the alternative, and nobody requested it.
It clearly should. I don't think there can be any question of that. And the reason I think it's ineffective assistance is because it's inherently prejudicial to the defense, as recognized in Gallagher. And in addition to what the Gallagher court said, what I just read, I
Did the
would.
judge have a duty at that point? We had a whole series of cases which culminated in Feingold. Started, I guess, in Suarez. And we had a whole line of cases. Doesn't the court have some obligation there to, you know, after here's the evidence to determine whether or not this is an intentional crime or a reckless crime, and dismiss the counts?
Well, if you have a reasonable view of the evidence that can support one or the other, then the proper way to proceed is to charge them in the alternative. I don't think the court necessarily is required to say. Well, I think if you have a case where it's depraved indifference and intentional murder, then it's a little different because they're both equal in terms of severity. But this is not a case where they were equal in terms of severity. They were different in terms of severity. And what I wanted to say was, adding to what the Gallagher court recognized as inherent prejudice, I think if you charge a jury that they have to return a verdict in all three instead of deciding with which mental state the defendant acted, you're decreasing the chances of a compromised verdict on a lesser charge than the top count. You're also decreasing the chances that the jury will exercise lenity. So I think, all in all, this was highly prejudicial for defense counsel not to insist that the court follow Gallagher, which was
If
I
the
was going to ask him to talk about the computer slides, but go ahead.
oh, you've talked about computer slides.
Talk about
All
the
right.
computer
Let's talk
slides.
about it quickly. Your red light's on. Go ahead.
Well, I think I've said what I needed to say on that issue. And I'll simply submit on the third
Slide.
issue.
Okay. Well, you'll have rebuttal.
Thank you.
Good afternoon.
Do you want to say something about the computer slides? since you don't have rebuttal?
Yes, I would.
Someone should say something about the computer.
I want to be the one to talk about the computer science.
Okay,
Why is
go
it
for it.
okay for you to display to the jury the law? Isn't that the province of the court as opposed to
Well, certainly in this complex situation, this isn't a pettit larceny case.
Right.
There are complex issues that the jury had to decide in regards to depraved indifference,
Right.
recklessness, intentional conduct. And when that's the case, we live now in a society that is visually stimulated.
Yeah, but the
And-
difference is the defendant's not going to do that. The defendant's not going to put up the charge and say, these are the things you got
Well,
to consider.
certainly, in this
all right?
case, he may have wanted
I'm
to.
almost done. And the judge can, and I think we, in a case in the Fourth Department, said it was okay, because the judge is the law. But if you're going to do it, it makes it sound like either you're telling the judge what to do, or the judge is giving a rubber stamp to what you say the jury ought to do. And it gives the impression that the two of you are acting in concert.
I don't think it's doing that at all. This is a closing argument. This is
Right.
not during the
And you're going to
charge.
say the judge is going to charge you on these elements, and here they are. And then you go through all of the elements, and then the judge says, now I'm going to charge you on the elements, and here they are. Now, which side is the judge on?
Well, again, I don't believe that this in any way would encompass some sort of judicial umbrella over the prosecution's closing
You can see where it
arguments.
might.
I can certainly see your point, but I don't, the point that's brought up by People versus Owen, the hazards that the court looks at there, that the jury is going to be left to interpret the law, and the court is emphasizing, what you're bringing up right now, the court is
Right.
emphasizing that one portion or another. This is a prosecution closing argument.
Right.
This
It's
is
always been my
supposed to be
experience.
persuasive.
It's always been my experience when you try to do this, even on the defense side, when you try to, horn in a little bit on reasonable doubt, the judge will, if you go too far, will say, Judge, or they'll say, Mr. Piggott, I'll take care of charging them on the law. You give your presentation and move along.
Well, what would stop a prosecutor from just reading it out loud? And if a prosecutor can make a fair
Judge,
comment
if
on
I'm
the
there.
law, if the prosecutor can make a fair comment on the law, then why can't a prosecutor show it on a slideshow?
Because one is a definition. If you slow it on a slideshow like that, you're giving a definition of the law.
Well, could
You're
I
not
read?
commenting on
I
it.
guess the question is, could I read the definition out loud? Could the prosecutor make a fair comment on the law with the preempt that the judge is going to give you the final instructions on the law, which was said here? The other thing that was said here in the judge's final instruction is that the court indicated that the closing arguments of counsel are not evidence.
Yeah, they always
And
do that.
two, that the jury must accept the court's final charge as the law in the case.
I guess
So
when you
if
see
there
a
was
slideshow, it sort of becomes almost like demonstrative evidence. It's right there, it's right in front of their nose. I mean, they can see it. It's there in black and white. It just
And
has an effect on, and that's why you use it.
Exactly. Exactly. And that's why I used it, because this is a complex issue. This
But aren't
case-
you then usurping the court? In other words, if you believe that by doing this, by showing it, you're emphasizing it, you're putting in front of the, that's what the judge is supposed to do, not you, not the DA. The DA is supposed to, and you're right, you can say, intentional murder has certain elements to it, and depraved indifference does, and I think the evidence shows that he acted recklessly, and et cetera. But to say, this is what you got to look at,
I don't think that as prosecutors that we have to close our eyes and make the jury's job harder than it already is.
Was any objection made to the content of the slides other than the fact of their being shown?
There was no objection in regards to the content being incorrect. There was an objection that the slides be shown.
So was it? Did they say they were slanted, or they they would mislead the jury? I mean, is it an agreed? In your view, is it agreed upon in this case that this was a totally correct and fair statement of the law that was being shown up there?
Yes, that's correct. And
It
in
was
fact,
statutory definitions, right? It was a statutory.
statutory
CJA.
definitions, they were marked as a court exhibit
Well-
so the court can review those if it so chooses.
were they statutory definitions or were they jury instructions, criminal CJI? Or did the two match? I thought they were CJI.
I think that you're correct, that it was jury instructions. But I believe that they match, so I don't think it would have made a difference. Again, I think that when the court and the final instructions gives those two statements, that one, closing arguments are not evidence, and two, that the controlling issue is the court's own final instructions, I think that would cure any sort of problem that you may have in regards to showing that. Again, these are complex issues, and we wanted to give the jury the best chance of understanding why our argument was for the certain crimes that were found.
Could you talk about ineffective assistance, and particularly, can you think of a strategic or tactical reason why the defense counsel might not have objected to the way the 3 counts were presented to the jury?
Well, first, in regards to the charge, one, I would say that this was not objected to and it's not preserved. And that is not a small point in this case. You have held...
But the question is, we're talking about ineffective assistance. So the question is, what strategic reason could he possibly have had to do that?
Well, I think that the exact argument that counsel made is a strategic reason not to ask for these in the alternative. The argument that counsel's made is that this would prohibit some sort of leniency by the jury. This would prohibit a jury from a compromise. I think my argument is
And I can understand why, but in the case of the lesser included, you can understand why sometimes the defense lawyer wants it, sometimes he doesn't. It depends on how optimistic he feels. But if, but it seems odd, it's unusual that he would be happy to have both counts there, but not in the alternative.
Well, if these were charged in the alternative, they would have gotten the manslaughter or they would have gotten the murder second charge first. Now, if they find him guilty of that, the jury charge would have been, you stop. You don't go any farther than that. You're going to find him guilty of murder 2, and he's done. Now, he doesn't want that. The defendant wants the jury to consider all 3 of them together. Let's talk about murder. Let's talk about man 1. Let's talk about man 2.
No, I don't think so. I mean, I think, you know, if your whole point is that it was not intentional, you know, in any way, you're not worried about that one. That one's probably going to go. In fact, you could probably put a slide. No, never mind. But you then are getting down to the reckless, and you're fine.
Well, again,
I don't know why having it would help you.
That's if you're asking me, is there some sort of argument to be made? That's my argument.
If assume that, I mean, first of all, do you agree that the man 2 is a lesser included of depraved indifference murder?
Well, man 2, obviously there's no element of depravity in man 2.
Well, that's why it's lesser.
Okay.
But it is a lesser included, isn't it?
Okay. Yes.
Assume it's a lesser included. If the judge had recognized that it was a lesser included, shouldn't he have given the so-called acquit first instruction?
Well, this was not the indictment charged murder in the second degree, depraved indifference, manslaughter first, and manslaughter second. That was in the indictment. The judge did charge as a lesser.
The same homicidal act.
That's correct. The judge did charge criminally negligent homicide as a lesser included on the 3rd count, which was the manslaughter in the second.
But should he not have charged, or couldn't the defense lawyer have rightly asked him to charge that you could not consider manslaughter 2 until you have acquitted of depraved indifference murder?
Well, that's not the way.
And then my next question can you imagine a strategic reason he might not want that?
Well, again, Judge, I don't. The indictment set out all 3 counts, so I don't think the judge would have needed to give a lesser included on that count. And again, I go back to my same argument. I don't think that the defendant wanted the jury to consider murder in the second degree by itself. If they consider that and they convict him, that's an A1, that's 15 to life.
You're saying that the defendant's happier the more confusion there is in there?
Muddle the issue. Now,
talk about the exclusion of the spectator. I mean, was it, why on earth did the trial prosecutor want that woman excluded?
Well, if I could, just before I answer that question, I think this just bears out a point, 2 points. One is when this was discussed in the jury charge, the defense attorney said, my client is not requesting that these be charged in the alternative. And that in and of itself, to me, indicates that there's been some discussion and that there's some reasonable argument that the defense attorney and the defendant have come up with in regards to why they all want this. He just doesn't say no objection. He says my client is not requesting that.
And can you can answer my question now?
Yes. First off, in regards to that, this is not violation or a public trial
My
issue.
question is why? What was the prosecutor thinking? What horrible thing is going to happen if this woman stays in the courtroom?
Well, certainly in hindsight, no horrible thing would have happened.
I mean, in hindsight, wasn't this a very foolish decision to make this issue? I mean, all you did was give him an appealable issue.
Every appealable issue may be foolish in some regards, but I think that it has to be put into perspective. This was a week-long trial. This was the first witness, the first prosecution witness, and the record will bear out. The prosecutor comes out of the back room, and here are all the defense witnesses sitting behind the defense table on his witness list. Now, this is the first prosecution witness very early on in the case, and certainly the prosecution didn't know where this case was going. Could there be some logical argument why this person may have been called either by the defense or the prosecution later in the argument? Then the answer to that is yes.
Well, I can understand, normally the people try, say to the defendant, I want your witnesses out. And the defendant may say to the prosecution, I want your witnesses out. In this one, the prosecution says, Judge, I want you to order my witness out. There's a ring of not...
I understand that, but you have...
You can ask your witness to leave.
The defense moved to sequester witnesses at the beginning of the trial. Prosecution witnesses and defense witnesses.
But are you saying that as a favor for the defendant, you asked the judge to order your witness out?
No.
Why would you order your witness
I
out?
think the idea was that there was certainly a question in the prosecutor's mind whether or not this person was actually going to be called by the defense.
No, you say in your brief that they had made it unequivocally clear that they were not going to call this person, and the reason why we exclude witnesses is so we don't want them hearing stuff and picking it up. Well, if you're a witness, it seems to me that you would want them there so they might be able to.
I think that there were some equivocal statements in regards to whether that person was going to be called, and I think that the other point that the third department pointed out is that the reason that the defense attorney indicated that he was not going to call this person is because he hadn't talked to her, because her counsel wouldn't have allowed that. Now, is that going to change during the trial, as the third department pointed out? That's certainly possible. I don't think this is a constitutional argument. This is a court discretion argument. And in that regards, I don't believe that this was abused in any way by the trial judge. As you've indicated, this was a split-second decision. There was an inquiry here. Certainly the record bears out why this person is here, why was she on the witness list, what types of information is she going to be giving. And in that regard, I think that the court fulfilled its obligation in relying on that information and making a proper decision. I want to get back, if I can, in regards to the charge to the jury in regards to the homicide counts, because I think it bears some, and maybe I'm being obtuse, maybe I don't understand this issue, and I've talked till I'm blue in the face on this issue. Is this a Gallagher issue or is it a Trappier issue? The Gallagher case specifically dealt with a homicidal act. And I think it's clear, and as I cited in my brief, becomes more clear when you look at the way this court cites Gallagher in Suarez and in Feingold when it deals with the specific issue of one-on-one homicides with a weapon. Now, I hope that this case does not implicate Suarez, Feingold, and I would hate to have people cite People versus Baker to make this more confusing than it already is for practitioners. I don't want that to happen. But I think that there's a distinction here in regards to what the defense is indicating in regards to the ultimate result. There is only one ultimate result to any injury. And certainly in Trappier, where the court found that there was a distinction in regards to a result, there was one injury. This dealt with firing a weapon. There was an assault charge, and there was a reckless endangerment charge. Now, in a homicide, there's also only one result, the death. But that's the ultimate result of the case. In regards to what I'm discussing here, if I can find my... And I'm specifically referring to the court's recent language in Suarez v. Burns, where it cites Gallagher You cite Robinson, you cite Trappier, and then you discuss applying this rationale in this case, the first jury's conviction of Suarez for depraved indifference murder would not be inconsistent with a subsequent conviction for intentional manslaughter. That's our case right here. They're not inconsistent. The court goes on to say, moreover, depraved indifference murder and intentional manslaughter are not inconsistent counts. A defendant can recklessly cause grave risk of death while intentionally inflicting serious physical injury. Again, that's our case here. The ultimate result in any homicide case is death. What we're arguing is that the result contemplated by the statutes under murder second, the result is recklessly causing a grave risk of death. Under manslaughter first, intentionally inflicting physical injury. Those results are different. And in that regard, our argument is that because they're different, that the charge would not necessarily need to be given in the alternative. It could have been given as it was in this regards to the trial judge.
Okay, counsel, thank you.
Thank you very much.
Counsel, rebuttal?
People v. Suarez reaffirmed People v. Gallagher. In People v. Gallagher, the defendant was convicted of both depraved indifference murder and intentional manslaughter, and this court reversed because the court failed to charge the jury in the alternative in that case. And Suarez dealt with a double jeopardy question. It didn't deal specifically with charging both crimes in the same case, in the same trial. That was a situation in which there was an intentional manslaughter indictment following the reversal of the defendant's conviction for depraved indifference murder on legal insufficiency grounds. So that Suarez has the holding, the language that counsel cites in Suarez really has no applicability to this case. In view of the brief time I have, I'll try to address some of the other arguments counsel made. As far as the display of statutory textual material to the jury, and this was statutory definitions, not the jury, not the CG.
Is your adversary correct that there was no issue as to the correctness or fairness of the content?
Yes, he is correct in that. That's not an issue here. I would like to analogize it to this. Let's say a prosecutor.
How much harm can it do for the jury to be staring all day at a perfectly correct statement of the law?
Because if you look at People v. Owens, what's the rationale why we don't allow written statutory textual material to go to the jury without the defendant's consent? It's because of the risk that the jury will give undue prominence to certain aspects of the jury charge at the expense of others. And what you have here, I would analogize this. Let's say the prosecutor during a summation handed to the jury a copy of the relevant penal law provisions defining these crimes and then collected them before the jury retired to deliberate. Would that be proper? I don't think so.
Yeah, but didn't the judge make clear that he gives the law here an unmistakable term?
Sure, but a judge does it in every case. But if the argument were correct that that cures it, then there'd be no basis to reverse in any case, even when a judge allowed written statutory textual material to go to the jury, because the judge would be telling them that the jury charges what controls and summations are not evidence, et cetera.
Isn't there a difference between what they look at during the prosecutor's summation, and presumably they can figure out that this is what he wants to show them, what the prosecutor wants to show them, and something that they take into the jury room with the judge's seal of approval on it?
Well, I think because of People v. Vincenti, you can't make that distinction, because Vincenti involved giving material to the jury at the conclusion of the preliminary jury instructions at the beginning of the trial, and that was held to be reversible error. That wasn't a case where the jury was taking it into the deliberation room with them. So I don't think you can make that distinction unless you want to overrule People v. Vincenti. As far as exclusion of the quote-unquote potential witness,
your opponent is right. His argument was that it was equivocal. I had misread it.
Well, at first it was, but later on it became unequivocal. And this notion that, well, the witness's attorney might have relented later on. Well, that's all speculative. You can't make a decision based on that. It's all speculation. It's like, well, Al-Qaeda might have dropped a hydrogen bomb on Elmira that day. I mean, what does that have to do with anything? It's all speculative. You can't make a decision on an issue that's important based on that. And that was something that my client never even got to address in a trial court because the appellate division springs this on us for the first time when the case is before the appellate division. They didn't even address the arguments that were made in the trial court. And I think there's something there that's fundamentally unfair to my client because now he's got an appellate court saying this when he has no opportunity to argue why that shouldn't be the finding. I think, that there's a due process issue there. I think at this point, I've made the points I need to make, and I
Okay, Ken.
won't trouble you any further.
You're not troubling us. Thank you both.
I appreciate that, but
Thank you.